Attention, everyone. We are live in 3, 2, 1.
I am calling this meeting of the Hillsborough County Land Use Appeals Board to order today, March 4th at 1:33 p.m. Introducing staff and the board members, Mr. Hisney, Ms. Rodriguez, Mr. Clark, myself, Ricky Bauman, the chair. To my left, the members of the board, Mr. Cornelius, Mr. Schwartz, and Mr. Hindi. Recording secretary is Augustine Guerrero. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in LDC 10.03.03.h and consist only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be staff's introduction, petitioner's case, opposition's case, rebuttal by petitioners. Only the following have standing to appeal or to intervene in appeal which is filed or may be heard at this hearing: the applicant, the administrator, any person or entity which appeared before the LUHO and presented testimony or other evidence or presented evidence themselves or by proxy to the LUHO and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentation to 10 minutes per side. This time limit may be extended for good cause. Pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The basis for a good cause extension: the case causes reasonable additional time. Proposed additional presentation is relevant. Proposed additional presentation is non-cumulative. Amount of time used to answer the board's questions. The board shall have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. Ms. Rodriguez, do we have a second appeal? Am I correct? Oh, just continuous. Okay, so we don't have to bother with that. Ms. Rodriguez, could you administer the oath to those offering testimony?
Those who will be speaking, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. We're going to be calling page 4, item 2A, appeal APP 220321, petition file number variance WS 211223, William Alvaro Diaz. The representative is Todd Pressman. The appellant is appealing the decision of the land use hearing officer who denied the request of a variance to encroach into the wetland conservation area setback. The location is 18107 Joreen Road, Odessa. Folio is 001-342.0300. The size of the property is 1.74 acres. The existing zoning is ASC 1. The future land use is R1. The service area is rural, and the date of the land use hearing officer was November 15, 2021. Sir, please state your name and address for the record.
My name is Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. Mr. Chairman and board members, it's my understanding there were only 4 members here today. We would like to ask the continuance to the April 1st hearing. I will make you aware, as my understanding, that the county code recognizes at the county commission level, if there's only 2 members missing, it would be if requested, it would be an automatic continuance. So we would request your consideration for continuance to April 1st on that basis. Thank you.
Madam Chair, this is Cameron Clark from the County Attorney's Office. I can speak to that if I may.
Please proceed, Mr. Clark.
Madam Chair and board members, this is the Land Development Code doesn't speak to this issue as far as continuances before the. Of course, now that I say that, I'm double checking it, but the LUAB bylaws, rules of order, do speak to this. First, it makes reference to there is one matter of right continuance that parties may ask for, but that has to be done at least 14 days before the LUAB hearing date, which obviously this does not qualify. And there is a provision in that same subsection stating that if the essentially they can request, the party can request a continuance at a hearing, but the board at its discretion may continue a petition at a board meeting without notice for unique circumstances. So I would only be concerned, Mr. Pressman stating on the record that his reason for continuance is just the number of board members, but just historically, it's not unusual for this board to hold hearings with a bare quorum. Obviously, this is a citizen volunteer board, and so there's no guarantee that the board's going to get a quorum, or I'm sorry, that the board's going to have more than 4 members. So, and likewise, just to state that language I just read to you is in both the Land Development Code and the LUAB procedural rules. And that's all I have, unless you have any questions.
Thank you, Mr. Clark. Then I would suggest, Mr. Preston, that we proceed because we have had occasions where we have not had a quorum. We had occasions where we haven't had sufficient members, where they resigned or dropped off for different reasons, and this is not unusual.
In response to the comment, I would raise that Mr. Alvaro Diaz is a citizen in Hillsborough County. I would suggest that he deserves the best chance possible for review of this request. At the county commission level, it absolutely definitively recognizes a difficulty if there's a low number of members, and there is an exceptionally low number of members today. I would suggest my opinion with respect to the board that in the case of a 4-member board, only 1 member can be looked at as denial. I think that's a more difficult standard. And on that basis, we would again request to continue the application without notice till April 1st. And we appreciate very much the board's consideration. Thank you.
Mr. Cornelius, any opinion?
Yes, I do agree with the chairman that yes, I believe we do need to be moved forward, as you said. And my short time here on the board, it is not unusual for us to have 4 members present with these hearings, and we do often have a difficult time of getting more than 5, quite honestly. So even if we were to continue with this, there is absolutely no guarantee that next month we'll have more members. And basically, I would say if we continue it, we could be continuing forever and forever because we can't predict the future. We have a quorum today. I believe we should move forward.
Thank you. Mr. Schwartz. We don't hear you.
Oh, all right. You can hear me? Yes, I agree. We should move forward.
Okay, Madam Chair, with that, I'm sorry. I was
Mr.
just,
Hindi, your opinion, please.
I agree as well with you. I'm on other county boards and we had the same issue where having just the bare quorum, we're lucky on those days.
Having heard the opinion of the board, which is unanimous to continue this proceeding now, and having heard from our corporation counsel, Mr. Clark, Mr. Preston, I ask you to proceed, please.
thank you. We'll be happy to. Let me just get my papers, please. And we appreciate the board's consideration of that. I do have a PowerPoint, which I'm going to go to some selected slides, if I may. So this was variance 21-1223. And mostly what I want to do is just orient the board to what was presented to understand and have your arms around the issue. Next slide, please. We're located up in the northern part of Hillsborough County. Next slide, please. And a little closer. Next slide, please. This was a reapplication of recently denied setback, but I want to be very clear that the first submittal was made by Mr. Alvarez, which was on a completely different set of criteria. The variance that we're asking has been reduced. Next slide, please. Single family home seeking a variance of 30 feet into the wetland conservation area for a proposed setback of 16.25 feet. Next slide, please. This is the reduction as of today, again, is 13.75 foot setback reduction. Next slide, please. Next slide, please. And next slide. This is how the property appraiser has the property. Next slide, please. This is the site plan of the home and the proposed pool. Next slide, please. Now, this is a critical aerial, board members. You see the subject site is towards the bottom, and you will see a very unusual, very singular, very curious, substantial reduction of the rear yard as compared to the homes to the north. That's unmistakable. That's a distinguished singular condition that dramatically reduces the width of this property. Next slide, please. Next slide, please. And this is just a closer view of it by aerial. You can see the dramatic difference in the width of the lot. Next slide, please. Or excuse me, depth of the lot. So by Google measurement, I have it at approximately 46 feet of a reduction of the depth of the lot. Next slide, please. And next slide. Next slide. Next slide. This appears to be a naturally occurring dynamic. You can see over the years that's been more and more erosion of that particular lot and seems to have stabilized at this point. Next slide, please. Now, this is important when I get to the hearing officer's decisions. When you look at this category for the footprint on the property, the gross square footage is less than 50% of the FAR or footprint allowed. Now, if I may switch to the overhead, please. So to specifically look through the hearing officer's items, criteria by criteria, this is very important, board members, because the hearing officer 100% recognizes the singular distinct hardship. Based on natural contours, this is reading from variance criteria 1 from the hearing officer, based upon the natural contours of Lake Taylor and the subject property has less depth from Joreen Road to the wetland line than some other properties in that area. So she recognizes the hardship that we presented clearly and distinctly. But what she then does is she, in criteria number 2, in criteria number 2, she ignores the hardship and refers only to the width of the property as being the difficulty. Like subject property, other properties like Taylor are encumbered, but notes that it is the width of a property that is wider than others, and that somehow addresses the specific hardship to the depth of the lot. Criteria number 3, when it looks at substantially interfering with or injure the rights of the others, the record evidence shows allowing the variance would permit substantial development to occur in the wetland conservation area, which in turn could cause adverse impacts. But the staff report clearly tells you and is stated word for word, this is the staff report now, a wetland setback compensation planting plan has been provided on the supplemental information plan dated August of 2021. That provides an equivalent square footage of compensation planting to the amount of encroachment. The hearing officer ignored that or did not include that in a result, yet she used that in one of our criteria, which is a mistake, along with stating the hardship and then saying the width makes up for it. Now, that's interesting because not many people build swimming pools on the side of their homes. Also, she was probably unaware, as indicated in the survey, that there's a 15-foot easement on the side, so that's not going to work. That's an encumbrance. And the septic tank is on the other side. None of that is included in the hearing officer's consideration for the width of the lot. Criteria number 4 is if it's in harmony with and serves the variance or serves the general intent and purpose of the LDC. She notes that it would alter the ecological integrity, balance, and character, filling, excavating, or placement of permanent structures rather than pervious areas in wetland conservation areas. Well, pools are built all the time close to water bodies. They're done with better engineering, and more plantings required. But that's again ignored by the hearing officer in criteria number 4. She notes again in criteria number 5, does the situation sought to be relieved by the variance result from a legal act result by the applicant or property owner? Well, as I've shown you, that's absolutely impossible because Mr. Everdiaz didn't go out there and dig out that huge rectangle at the back of his property. That's a naturally occurring singular hardship condition. But the hearing officer again rejects that and indicates for some reason, which is important, that the size, shape, and configuration did not leave room of the addition of the pool and deck. But I've showed you that the footprint of Mr. Alvarediz's home is only 50% of what could be allowed in that lot. So it's impossible to say that he overbuilt the lot because he didn't. It's actually factual to say that it is 50% less footprint on that property. So that criteria with respect to the hearing officer is incorrect as well. And the criteria number 6 will allow the variance result in substantial justice being done, considering both the public benefits intended to be secured for the individual hardship. Again, she refers to the self-imposed individual hardship, but that again is an impossible finding because he is far below the FAR or footprint of the property, and he did not create the tremendous difference in the depth of his property. So in all circumstances, virtually all criteria, the hearing officer recognized clearly. She states she recognized, again, she states that she recognized based on the natural contours of Lake Taylor, the subject property has left depth from Joran Road to the wetland line. So she recognizes that as the hardship, yet ignores it for follow-up criteria because it's wider, but didn't consider what was in those width areas, and then tries to claim that with respect to her, that it was self-imposed, even though you can clearly see from aerials without discussion or without any factual information otherwise, that it was a naturally occurring area that diluted or minimized his lot. With those points, we appreciate your consideration. This request is just about a single residential home who would like to be at par with other homes on the lake. There's many homes on the lake. They all enjoy the lake to minimum standards. And Mr. Alfred Diaz would like to be able to do the same thing. I'll be happy to answer any questions you might have. Thank you.
Mr. Preston, I have one. The main issue that I have and that I don't quite understand is we had a lot wider than some, wider than, say, the adjacent ones, but there's one clearly 3 houses down that is just as wide or appears almost as wide. This is a new home. This is not something from 1960, 1980, 2000, or whatever before zoning even could have changed. My issue is that in building a home, a new one, in whatever footprint you want on this empty lot or whatever they took down, that pool could have been planned for in that area. I understand about the square footage and whether it could have gone sideways or an L shape, or we're not even going to try and second guess that because that's not our business. But the new home, and now they want to encroach in the wetlands. I have to agree with the land use hearing officer. I think that that is what we would call a self-imposed hardship.
May I respond?
Well, rebuttal will be from, oh, yes, please.
I don't want to interrupt you. You have some good thoughts there. No question about it. But a variance is based upon a topography and geography of a piece of property. And there clearly is something different with this property than others. The hearing officer recognizes that. So the basis of prior knowledge or what you're going to place on a property, with all due respect to you, is immaterial or secondary. The issue is very simple and straightforward. Is this lot different than others? We know it's not. We know it's deficient in depth. That's a hardship. That's a hardship. A variance is then warranted to make up for that hardship, which in this case very clearly is depth of the lot.
In my opinion, the size of a lot is what you deal with, but that's my opinion, and I'd like to have the other board members weigh in.
May I make one quick comment, very short, if I may, with respect?
Well, you've already answered me, so
Just on your last
we're
comment?
going to agree to disagree on this particular.
Yes,
point.
ma'am. Thank you very much.
Mr. Cornelius?
Thank you, Ms. Baumann. Mr. Pressman, similar concerns that Ms. Baumann raised. Just a question in terms of the footprint of the house or the size of the house that you're testifying to, that you are saying it's under the FAR. Is the footprint, is it a one-story or two-story building? It's one story. Okay. Okay.
No, I'm sorry, sir. Mr. Alvarez is saying two-story.
Two stories.
Yeah.
Okay, thank you. And I just, that helps me understand this. Okay. So what I do agree with Ms. Baumann is you have the site condition that you have. I do understand your testimony that if you look to the north, those lots are deeper. If you look at the lot adjacent to your south, they're more restricted than you are with your property. They appears they have an even shallower, especially where their home is located. So there are limitations on many of these lots along Joriane Road. It's not just this one property, as I look at it. So I do also will say in terms of the FAR part of it, the way I see it is that's a maximum. You're also limited by other factors, other standards, other setbacks, on other limitations. I would say very few homes actually end up building out to the maximum FAR that could be done because of other limitations or restrictions. So I will say I do concur that I think the hearing officer did make the right decision.
I just have one question. What year was the home built? Thank you.
Mr. Alvarez, for the record, Mr. Alvarez is saying 2021.
Mr. Hindi?
You know, we have the wetland setbacks for a reason, to protect the water bodies. You know, as you showed in the aerial, I believe it was 2002, the water levels were lower. You know, as times change and environments change, you know, they're there to protect the water bodies as well as the adjacent residents. And encroaching into them, you know, it's not the best solution. You know, proper planning early on is the solution.
Does any other board member have any questions of Mr. Preston? Mr. Preston, you may have your rebuttal.
First of all, we appreciate you being here today. We appreciate your consideration, and we appreciate you serving on the board. I would say to you that you have to look at this property as it exists. And the hearing officer clearly found that it is unusual. It is singular. So you go from A to B. A to B is, well, where is it deficient? Sufficient in depth. So whether this home was built here or not, this lot has a hardship. It's inescapable. It does have a hardship. Does adding width to the lot make up for it? No, it does not, because it does not address the specific hardship that the hearing officer found. So I would suggest to you in the strongest terms that if this were a tree in place of a wetland sticking up where a home couldn't be built, that would be a hardship. So whether it's a tree or whether it's a reduced lot or a change curve lot size, you still have a difficulty. And in those circumstances, a variance is warranted. And what we've requested is the absolute minimum. I mean, it's small. The resulting swimming pool is very small on this property, trying to work with the county. And the other thing I'll say to you is that we've received absolutely no opposition from all the mailings and notices that are out to the public. No one has spoken in opposition to it. Mr. Alvarez' family would just like to enjoy a small pool in their backyard. Staff has indicated in regard to Mr. Eind, if I said that correctly, has indicated that a supplemental planting plan has been provided, which will make up that difference. Pools are added all the time in wetland conservation areas, and they are compensated for. That's a normal everyday event. So with that, again, we appreciate your time here today, and thank you for your time.
Thank you, Mr. Preston. Members of the board, it is now time to either validate the land use hearing officer's opinion or remand it back to the land use hearing officer. Mr. Hindi?
I'd like to make a motion to adhere to the land use hearing officer's opinion.
Thank you.
This is Mr. Cornelius. I will second that motion.
Thank you. Any discussion on this?
Ms. Baum, I'd just like to make one brief statement. Mr. Pressman does represent that the land use hearing officer said this is a singular incident situation. However, if you read the actual words, that's not what she says. She says that, let me get to it as, basically she says some properties. She does not say this is the only property. She says some properties. So that is why I believe she is correct in her decision.
Yeah, thank you. All right, Mr. Hindi? Aye or nay?
Aye.
Mr. Schwartz?
Aye.
Mr. Cornelius?
Aye.
And I also say aye. Ms. Rodriguez, note that this is a unanimous decision to uphold the decision of the land use hearing officer in this case.
Got that. Okay, the next case is on page 2 of your agenda. This is a continuance from the December 10th hearing. It is appeal number APP 21-1309, petition file number variance 21-0802. The appellant is Ronald C. Wang. The representative is Harold Wang. Is to appeal the decision of the land use hearing officer who denied the request for variances to the required minimum lot size and required minimum lot width. The location is 1601 Sefner Valrico Road. The size of the property is 4.95 acres, more or less. The existing zone is ASC1. The future land use is RES4. Service area is urban. And the date of the land use hearing officer hearing was July 26, 2021. And we have Mr. Wang virtual. Am I able to see him?
Hello.
I can't see.
Hello.
Yes, just a moment. Sir,
Yeah,
raise your right hand.
Yep.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may proceed.
Thank you.
Did you state your name and address for the record?
Okay, my name is Harold, last name Wayne. The address is 1601 Sefner Verico Road.
Proceed with your testimony.
Yes. So, so I should speak now?
Yes, go ahead.
Yes, sir.
Okay. Yeah, I think I sent in a written statement is talking about, because I got a reject on this proposed, and that on the written statement, we're talking about is answering why they rejected. Well, like the number one, which say we didn't show proof of the variance will create more taxable value and income to the county. But if we've been approved to 3 lots, then will be more property tax, public water, sewage, electricity, those income to the county. And the second one say the variance, if allowed, it won't substantially interfere with or injure the right of the neighbors. Well, because we sent out all the information about the hearing, there is no opposition of the application from the neighborhood. And the number 3, the literature requirement of LDC did deprive the property owner rights commonly enjoyed by others in the same district and area. Yeah, because like around there is a Long Pond community just crossing the lake from this property. They have divided like 5,000 or 8,000 per house, So according to the LDC section 11.04.01, this property is designed residential 4 in the comprehensive plan, which will allow a potential maximum of 10 dwelling units. And we only apply for 3, so it won't bring any constitute of a density, variance of the neighborhood. And the deny of the application, we already spent over 2 years on this project to try to separate it in 3 parcels, and we spent a lot of time, a lot of money, and just because of this property basically is allowed for 2 parcels. But I have our family has 3 kids, so that's why we considering to split to 3, and a lot of effort we have put in. So the deny, it actually caused a lot of hardship on our family, and the granting of the variance won't be obligate the property owner from attaining all additional requirement, the license, permit, so you don't have to worry about we will illegally, after approved, do some construction on there. Yeah. So based on the foregoing, so I think please have the board of member reconsider the approval of the request of variance. Yeah. That's all.
Thank you, Mr. Wang. Mr. Wang,
Yes.
I have one question for you. I understand that you want to subdivide the property into 3 lots where 2 would not require variances. Am I correct?
Yes.
Thank you. Does any other board member have any questions of Mr. Wang, Mr. Cornelius, Mr. Schwartz, Mr. Hindi? All right, thank you, Mr. Wang.
Okay. So I just wait for the written notice or
No, there's no one else to testify.
Okay, Ms. Rodriguez confirmed that there is no other testimony, so the board will discuss the matter, Mr. Wang.
Okay. So I just wait for the answer.
Yes, please.
Ms. Bowman, if you're ready for a motion, I'm ready to
Mr.
make a motion.
Cornelius, please.
Yes, Ms. Bowman, I'll make a motion to uphold the land use hearing officer's decision. I believe she properly applied the criteria and found no hardship and did not meet any of the criteria. So I do recommend we uphold her decision.
Do I have a second?
I'll second it.
Thank you. Is there any discussion on this matter? If not, then I will call the motion for a vote. Mr. Cornelius,
Yes?
Mr. Schwartz,
Yes.
Mr. Hindi,
Yes.
and I chair, yes. Ms. Rodriguez, please note the decision of the board is unanimous to uphold the decision of the land use hearing officer.
Noted.
Mr. Wang, the board has decided that the land use hearing officer's decision was correct.
So which means I can only steal like 3 years ago 2 lots only.
That is correct.
Okay. Okay. And can we all property just change, hire some people to divide it in 10?
I'm not understanding you, Mr. Wang.
Oh, because right now it's variance. The variance that definitely gotta reject. But can we just turn to changes only?
Change to what, please?
Zone. Yeah.
You can make a new plan, yes. You are allowed to make a new plan. Mr. Hisney, is it any time limit on that, please?
Yeah, well, when it comes to a variance that's been denied, applicants can reapply for a variance, but if they reapply within 1 year of the denial, there has to be some substantial changes to the request that are outlined in the code. So Mr. Wang cannot simply come back and ask for the exact same variances. But as you mentioned, I mean, if he wants to go forward with a subdivision of the property that does not require variances, then certainly he can do that. But if he's questioning about applying for another variance, there's criteria in the code as to how that it has to be substantially different in different ways, or he has to wait a year.
Thank you, Mr. Hisney. Mr. Wang, did you understand that?
So which means I have 1 year from today.
If you try
that?
to do the same type of 3-home
Lot.
subdivision, you would have to wait a year. If you are
Okay.
doing something different, you can apply right away.
Okay, but do I need to, if I wait for 1 year, do I need to repay all the fee again?
Mr. Wang, can I suggest that you contact me at my office after the hearing? We're having a little difficulty hearing you because the kind of an echoey effect. I'd be happy to discuss it in detail with you as exactly what you could and couldn't do or request. But I think it'd be more effective for you to call me at my office sometime after the hearing. Let me give you my phone number. If you have some paper there to jot it down, it's 813-307
Okay.
4504. My first name is Tom, and I'll spell my last name for you.
Okay.
HIZNAY. And that number is the direct line to my desk. So I'd be happy to discuss it in detail with you, what your options may be. Okay, sir?
Okay. Thank you very much.
You're welcome.
Next case is on page 3, item 1A, appeal number APP 22-0314. The petition file number is variance 21-1278. The appellant is Carolyn Stewart. The property owners are Christopher and Candace Perez. The appellant is appealing the decision of the land use hearing officer who approved the request for variances to the required rear yard setbacks for the existing single-family home and accessory dwelling unit and the side yard setback for the existing pole barn. The location is 1101 Swilly Road, Plant City. The folio is 093154.0000. The size of the property is 0.83 acres more or less. The existing zone is AS1. The future land use is RES1. The service area is rural, and the date of the land use hearing officer's hearing was October 25th, 2021. And please state your name and address for the record.
Yes, can you hear me okay?
Yes.
All right, my name is Carolyn Stewart, and I live at 1204 Swilly Road. And if I may proceed?
Please.
Okay, thank you. Well, good afternoon. First, I would like to draw your attention to, because I don't believe they were considered by the land use hearing officer, was a prior objection brief I submitted when the variance was initially going before. And the reason I say that is because during the course of events, I had submitted the property appraiser's view of the property that showed the accessory dwelling unit as being a garage and always being a garage. And she hadn't seen it. So the bottom line up front is that I believe the land use hearing officer perhaps got a little confused in the decision and applied the wrong facts to the requirements for a variance. No accessory dwelling unit existed prior to this time. The previous owner made some changes. There's no evidence anybody lived there. There's hearsay that maybe a parent used it for some reason, but it is outside the building code and it's outside zoning. It's single-family residences for the area. So I don't see any legitimate reason within the categories and the criteria that apply to variances that would allow this. As to the pole barn, again, the property appraiser carries that as a carport. That is an issue that I'm not going to address here today because to me, that's the rights of the property owner at the next residence. And basically it's an encroachment and I don't think that can be done here. What I would say is that there are, throughout the entire neighborhood, it's single-family homes. And what they're trying to do here is create an accessory dwelling unit to make it a multifamily residence. And this ignores the existing law and code, and with no rational reason for that, because the prior owner never attempted to make it an accessory dwelling unit, and it's shown on the purchase. Further, when the appellees purchased the property, they were on notice that it was unpermitted work and that it could be a man cave or something else. And that was in the record for the documents they provided. So a key thing is that the land use hearing officer's ruling was not even based on anything conditional, such as, well, this will be temporary just for your parents until they get their own apartment or whatever. This is forever. So realizing that this puts an Airbnb or a second rental, second multifamily residence on the property where none previously existed. So to talk about this, prior to meeting the examination, we should start off with, under Florida statute, the structure is prohibited. It's 940 square feet where the limit is 900. Now, what went in the record initially was 900 or less, but the appellees came back twice and doubled down with their written paperwork saying that it was 940 square feet based on another survey they obtained. Right then and there, it should have been done. When we go to the 6 criteria, again, I want to state there was no long-standing accessory dwelling unit, and the hearing officer seems to have taken that it did exist. An accessory structure existed, and that was built okay. It was within the building code and the zoning. And it was a garage. It was a garage. Her reason for number 1, talking about a hardship, there's no hardship due to the land. She used the fact that their property is 0.83 acres and less than an acre. They had already received non-conforming property because the home was within 50 feet of the property boundary. That's not an issue here. An issue here is the accessory dwelling unit. And there's no casual or no harm to them because whether your land is less than an acre or more than an acre in the neighborhood, you don't get to just put up a multifamily residence. If they wanted to add on to their house, they could do that. That's a different issue. But the hearing officer based it on the fact their property is less than an acre. There are many properties in the area less than an acre. This was all done prior to 1987, 1989, when a number of the larger lots were broken up. So the other thing is this changes the law. It basically, I don't know what law allows, well, if it's less than an acre, you can put this, but everybody whose property is more than an acre can have an accessory dwelling unit, and they can't put it right on top, which this is going to be 4 feet from my property boundary, approximately. So the bottom line is what was in the hearing was this was for their economic convenience. They want their parents to live there and provide childcare. It's an in-kind rental. There is nothing in the decision that said, well, it's only good for your parents. So this is forever. This can be a rental, second, multifamily, Airbnb or whatever, forever. There was no conditioning on this. And again, when I say it's less than 50 feet, but it impacts me, but it impacts the entire characteristic of the neighborhood. So on condition number 2, deprivation of rights, she said they had a deprivation of rights. They had no deprivation of rights. When they bought the property, they signed a form. They knew it was unpermitted. And it said in there, if you want to do anything else with it, you have to get permits and approval. They were on notice, and nobody in the neighborhood has the right to do what they've done. So there's nothing peculiar to the land. There's nothing unique to their land. They could buy a $25,000 ADU and put it next to their house on the east side if they get a permit, okay? But nobody else has the right to just turn their garage. And like I said, if the entire neighborhood does that, which is the law being created here, then there's no more neighborhood. It changes the characteristics. It deprives everybody else of their rights. And then on the area, does it interfere with the rights of others? Well, yes, it does. Everybody else bought in this area, and this was testified to by another person at the hearing, that they bought thinking it's single residence homes. So again, it's interfering with everybody's rights. And as regarding the rest of the decision, again, the same facts, and I would say the same faulty logic, and I don't know what led to this other than confusion and perhaps sympathy. It's very sad if they bought this and had the understanding their parents would give up their lease and their rental wherever they were and would come help. but that doesn't preclude the fact that there are 5 bedrooms in the house and their parents could live in the house. This is not a hardship, it's an economic preference, which if their parents, and this was brought up at the hearing, if their parents leave, what we're saying is if they say they need childcare, they're bringing in other au pairs and whoever else and renting out. If they qualified for a mortgage and now they're saying it's too tough, well, so everybody now with inflation under this is hearing officer made law. Everybody else can say, I'm suffering, so I need to create my garage as a living unit. And that's not where we need to be going here. We need to cut inflation. So with that, I will, unless there's any questions you have of me, I just want to close with, I think it got off track with a lot of emotional testimony previously, blame, ad hominem attacks on others. And the fact is, by these 6 requirements, the hearing officer made a mistake. Thank you.
We have the owners of the property here. Please come forward.
My name is Candace Perez. I live at 1101 Swilly Road, Plant City.
Sir?
Chris Perez, 1101 Swilly Road, Plant City.
So as we stated in the previous hearing, everything that exists on the property, all of the variances that we were applying for did exist at the time of our purchase of the property. It was one of our non-negotiables when we purchased our property that there were a mother-in-law suite. We were told that there was unpermitted work. Me and my ignorance, I didn't know that unpermitted meant that it could be illegal. I thought that it was a simple, we would have to obtain after the fact permits, which we will do as soon as the variances are granted and allowed to be granted. We were told before we came that if we were granted variances, she told us that she would appeal, so we were just holding off. But we do have every intent to apply for permits, after the fact permits for the mother-in-law suite and the pole barn. We had submitted a petition previously from the people in our neighborhood. We went door to door, and everyone that was home, save for the person who rents from Carolyn Stewart, was willing to sign our petition in favor of us being granted the permits for both the pole barn and the accessory dwelling, the mother-in-law suite. My parents are the ones that live there. We have no intention of renting it out or turning it into an Airbnb. The only reason that we sought to have it changed to an accessory dwelling in the first place was because of the complaints that were made by Ms. Stewart to code enforcement. And so this was the way that we were told that we could fix the problem, was to apply for these variances, and that's what we did.
I have notes just to that I'm not going to read from because my wife did a great job of.
No, there is
Getting
something
some of
on
it?
here that, so she also talks about the 900 square feet or less, but the living footage is less than 900 square feet. Like the footprint of the building is not what the living footage of that building is. So I think that's it.
Mr. Hisney?
Mr. Hisney, on the zoning on this, does the house and garage predate the current zoning requirements?
What zoning requirement would you be referring to?
For these various setbacks and things.
Well, I mean, I can't say, I mean, we reviewed this as a variance. However, generally speaking, structures that are in place prior to July 26, 1989 can be certified as legal nonconforming structures. Whether that's the case here, again, I don't know off the top of my head because that's not what we were reviewing.
Thank you.
Our house was built in 1969, so we did have to apply for the legal non-conforming lot when all of this came up. And then the
Board members,
now,
I'm sorry, this is Cameron Clark. May I intervene? Just want to remind that any information that was not entered to the record before the LUHO should not come in as new information now. So any decision by the board has to be based only on the evidence that was reviewed by the hearing officer. Thank you.
Chris Granular did present that information the first time around. So the building that's now in the accessory dwelling was previously a garage, and it was built in 1985, but it was, as she said, originally a garage. It was converted sometime after the fact by previous owners.
Thank you. And we've noted, that's in the record, that as Mr. Hisney stated, these are built before 1989. Record has the house as 1965, and the garage, which has been converted, is 1987. We do understand that you were cited by code enforcement, so that is not a legal use at this point. And again, you went through the variance process. Thank you. Mr. Hindi, any questions of the owners?
No, I don't have any questions. Thank you.
Mr. Schwartz?
No question, thanks.
Mr. Cornelius?
Ms. Bowman, I actually have a question for the appellee, if I could have that.
Thank
And none
you.
for the.
Thank you.
Ms. Stewart?
Yes, please.
Mr. Hindi, any questions of Ms. Stewart?
No.
Mr. Schwartz? Mr. Cornelius?
No.
Yeah, Ms. Stewart, just a real quick question here in terms of your concern about the variances and your objections to the variances. So there are three, correct? We have for the house, the pole barn, and then the garage, which hadn't been converted. I just want to be sure that I do understand in terms of your objection. What I'm hearing is that your main concern is the conversion of the garage to the ADU, because our variances that we have aren't about the use, but it's about the setbacks. So what I'm asking though, in terms of the house and the pole barn that have been there a long time, I mean, do you have objection to that? Because that's how they've been there for a long time.
Okay, so this is part of the incorrect information. The house has been there for a long time. And as I understood it, the land use, somebody wrote a letter and said, you have, because of this kind of grandfathered in, you're okay. I'm not objecting to the house. That was there. The pole barn was not there. That is a recent development. And until these matters came up, nobody knew that it actually encroached on the neighbor's land, both with the pad and additionally with the overhang, or that the owner who allegedly said, I don't mind, well, that's a tenancy by the entireties, and this isn't 1905, so his wife gets to speak, and she has not. There's nothing in the record. So that's a legal, ineffective statement. And I'm talking about the accessory dwelling unit where a garage is there, and that was fine, because back then, as of now, it may be within 5 feet, whatever, it's 4.4 feet, of the property line. That met it then, it met it now, it met it when we bought our property. An accessory dwelling unit never existed there. They want to turn it into an accessory dwelling unit. The previous owner did not take steps and did not do that. The last time I was inside the property was in probably 2016 or 17, and there was no accessory dwelling unit. It was a garage. I saw the garage door open all the time. So all the allegations and hearsay, that accessory dwelling unit becomes a multi-family residence on a single-family residence home on the property. And just because it's less than an acre doesn't make any difference. It makes a difference to me that it's 4.5 feet from my property, but it makes a difference to the whole neighborhood and the characteristic, because this is new law saying, well, if somebody did something wrong, you get a free pass, just get some permits, and now 100 homes in the area can become multifamily residences. That's what this is saying. So in my rebuttal, I would say again, I'm not arguing that here. I'm sorry that the owner's not here to do that because he's negatively impacted. I'm not sure he read anything about this or is aware, or that his wife is even aware, but he can't sell property. I said previously in the other hearing, he could sell them an easement that's temporary until they correct that carport that's partially enclosed. That's not my concern. Yes, my main concern is the accessory dwelling unit, and that has not been there for any period of time.
Thank you, ma'am.
Okay.
Ms. Stewart, that garage has been there since 1987. By your testimony just now, you actually saw the interior 2016. So in actuality, now it's, I don't know when the sale was made, when these people moved in, the Perez's, but whether it's 2021 or 2022, that's 5 years of you having no knowledge of anything going on. So you personally do not know who made the conversion. By their testimony, and we're not going to look at real estate advertisements and things of that nature. We're not even going to get into that kind of stuff. But point being is that their testimony is that it was already done, but we have no way to contradict that. And I certainly can, and certainly you can't either, because you have no personal knowledge of what happened in that unit since 2016. We don't know if the previous owner did it or if the Perez's did it at this point. We have no way of knowing. So we have to go by the testimony of the land use hearing officer that says it was done previously.
Well, the implication of land use hearing officer is that it was long-term and long-standing, and it was not. And I know that as of 2016 and 17, it was not.
No. What the land use hearing officer was only saying is that the house was built in 1965, the garage is built in 1987, and whatever issues those things have in reference to the lot lines are quite old.
Well, there's no issue with the garage. That's what I'm saying. There's an accessory structure. I don't have any issue, and nobody in the neighborhood has an issue, because people in the neighborhood, 90% have garages, and they fall within the building code and within the zoning. That garage is okay as a garage. I've said before, I don't care if it's a family unit, but a rental multi-family unit, turning it into an accessory dwelling unit, is a change in land use. The structure itself, they don't want the parents to live in the house. They say, we got an extra bedroom, stay out. That's the problem here.
Well, yeah, we understand that, and that's why they have to get building permits. That all has to be okayed by the building department.
Well, it's new law, because it is within 50 feet of my property, and that's a violation of the zoning. The garage is not, but an accessory dwelling unit is in violation. The garage is okay as a garage. There's a reason the Florida statutes were written as they were. And the 900 feet, I don't see how we're surmounting that here, because the Florida statutes are clear. They don't say, well, living space in this. It's 900 feet for the structure. And theirs is 940 feet, and they doubled down on it. So we have a larger structure than is allowed, and we're looking for a use that violates the law.
Mr. Hisney, I was just going to call on you. Thank you.
Yeah, hi. Let me address a few points raised by the appellant. Before I do that, I'd like to point out that in the code regarding the conduct of hearing, says that the land use hearing officer, who I represented this, and parties to appeal may freely refer to applicable portions of the Hillsborough County Land Development Code. So with regards to the question of whether the addition of an accessory dwelling unit to a single family lot constitutes a multifamily use as regulated by the Land Development Code, the answer is no, it does not. Accessory dwelling units are allowed in agricultural and single family districts subject to the requirements of this code, and the addition of an accessory dwelling unit to a single-family lot does not constitute multifamily use. And then also, I think it was mentioned by the appellant that the code prohibits accessory dwelling units on lots larger than 1 acre. Again, that is not correct.
That's not what I said.
Okay, I thought that was stated, but.
No, I was saying what is the hardship only because their lot is less than an acre? When nobody else could build an accessory dwelling unit 4 feet from the neighboring property?
So also then, so I'm available for any other questions you might have.
But Ms. Stewart, we have to focus on what's here. That is not a new unit. That building has been there since 1987.
Correct.
Yes, it was converted to an additional dwelling unit, a possible additional dwelling unit, subject to code. And that's where the permits and all that are required, and that's why the variances are required. So the Perez's have gone through the variance process. In addition, when this is over one way or another, they're going to have to do something about the garage / additional dwelling unit to make it legal either as a garage or as a living unit. That's their issues.
Well, in rebuttal to that, what I would say again is that this is creating new law where everybody in the neighborhood can take their garage or accessory shed or anything that's within 50 feet of the neighboring property and turn it into an accessory dwelling unit and collect rent. And that is what other people in the neighborhood objected to at the last hearing and object to here. This does not follow the law. They presented only hearsay at the last hearing in a claim that it existed. They alleged in their documents that they put in their property appraisers' pictures. When they did not, they put in Zillow pictures that showed nothing. So in this case, we don't know, but they brought the problem to the property. The previous owner did not create an accessory dwelling unit, or he would have put one on the record. And in fact, the Perez's have not even gone to the property appraiser to change their taxes, as was shown last time. So here we're talking about it's still a garage, according to the property appraiser. Nobody converted it. They want to do that now with claims that maybe it happened in the past and no proof. So I am saying I object to that because it is against what is in the code and the law.
Ms. Stewart, we went back and forth with this before. You have no proof it wasn't done by the previous owner, nor do we have any proof that it was done by the Perez's. So we don't have to keep going there. We're just going to leave it there because you have no proof. The only proof that they have that they could possibly get was not at the land use hearing officer's hearing. So this is all hearsay. So we do not know who made the conversion. The point is that there was a conversion. It's not properly permitted. We agree on that, but that's all we're going to agree on. Thank you.
All right. Any other questions? Thank you.
Mr. Hindi, you have any other questions of the appellant or the plan?
I do not, but I would like to make a motion.
Please.
I'd like to make a motion to uphold the land use hearing officer and allowing the variances to proceed.
Thank you. Mr. Schwartz?
I'll second.
Is there any discussion on the motion?
Ms. Bowman, just have just a short amount of discussion, very short, because the only thing I was thinking a bit different than the motion is that I fully agree on the two variances, 100%, with the house and the pole barn. The issue about the encroachment, that's a private matter between property owners that has nothing to do with what we're looking at today. The only thing that I'm thinking in terms of the garage conversion to the accessory dwelling unit, and I completely agree, we don't know who did it, but that doesn't play into what my thought is here, is we do know it was converted without going through the proper process. It doesn't meet the code requirements for an accessory dwelling unit. So where I kind of am looking at this differently, I don't think the findings of the land use hearing officer necessarily would apply to the issue with the garage conversion to accessory dwelling unit, because I do think that's a different kind of situation and issue. If this was still just a garage, then clearly it falls under everything the same. It meets it, it's okay. But my thought is the code has requirements for setbacks for accessory dwelling units for a reason, and this one doesn't meet it. And I don't see anything in the record to say that an accessory dwelling unit being less than the required, I believe it's a 50-foot setback is what the report says, does meet that criteria. So that would be my difference in terms of your motion, sir. I understand it. What I would have said was I would support the findings on the house and the pole barn, but ask the special land use hearing officer to relook at the accessory dwelling unit for all of the criteria, and specifically about that being an accessory dwelling unit. But that's just my thought.
If in our documents that we received for this case, I don't know if everybody's dug through it extensively. I hope we have. There is the listing description for this property that they purchased at the time. May I read it? It's on page 196 of 251. It does say that the garage has been converted to an in-law suite, in-home office, or man cave, kitchen setup, bath, and extra room. It does state it, and that was in the real estate description at the time. Apparently, from my understanding, if that was the case, there was never an issue prior to the sale of this house. It has only come about since the sale of the house.
Clearly, if this is not, again, I'm a realtor. This is not the MLS or something like that where I would say, oh, okay, this is what they bought. This is how they did it. From this appraisal software, I have no idea what that is or where it's coming from. This again would create a presumption that this was done before, but we don't know. We technically don't know, because I don't find this to be competent evidence without some kind of certification that, this is an MLS entry, or this is from, Johnny Jones appraisal company or something like that. I don't see that. I got it with the pictures. My gut feeling, yeah, it was done. But I don't know that. Mr. Schwartz.
Yes, I was looking at the seller's disclosure dated 12/20, and the seller, when they purchased the property, it states on it, they signed it and said that garage conversion for family member was done without permits. It says on the
What page, please?
I'm on page 79.
This is not the seller's disclosure. This is a contract for sale. This is only part of it. We don't have the Yeah, we have initials, but we don't have the signatures.
Yeah, Ms. Mallon, what I would say too, and I fully agree with you about, who did it. I think for our discussion for this issue, it really doesn't matter who did it. It's there. And, it's there. And that's why the variances is needed, because it's there. So that's all I say to that.
No, I agree with you. The variances are required to make everything legal, whether it's an additional dwelling unit or a garage, because the footprints are the way they are vis-a-vis the lot requirements in the zoning. So I think we all agree on that. Now, the question is Mr. Hindi, are you willing to accept Mr. Cornelius's modification to your motion?
No, I would like to keep my motion to follow the land use hearing officer to allow for the variances to pass, with the understanding that if approved, the required permits will be received, for this dwelling structure.
Well, that would be the owner's responsibility vis-a-vis code enforcement,
Correct.
because they've already been cited. So if these variances are approved, they certainly have to
As the
go
next
get
step.
the after-the-fact permits and get the blessing from the building department and all that kind of stuff. That's their responsibility. Mr. Schwartz, your opinion on this?
No, I still support his motion as stated.
As do I. So, Mr. Cornelius, your modification fails. And therefore, I will ask for a vote on the motion. Mr. Hindi,
Yes.
Mr. Schwartz,
Yes.
Mr. Cornelius,
Respectfully, no.
and I as chair, yes. Motion passes 3-1 with Mr. Cornelius dissenting to uphold the decision of the Lujo.
Noted. Board members, the next hearing is going to be April 1st, and we do have a case scheduled for that. So you should be receiving the packages within a couple of weeks. Actually, one case.
Thank you, Ms. Rodriguez. And therefore, we have completed our business and we can adjourn this land use appeals board session. Thank you for coming.